If you saw headlines calling Trump's Second Amendment executive order a historic win for gun owners, you need to understand what that order actually does and what it does not do. Because there's a lot of hype, a lot of celebration, and frankly, a lot of confusion. On February 7th, 2025, President Trump signed an executive order titled Protecting Second Amendment Rights. Gun rights groups praised it. The NRA called it a monumental win. But here's what most people don't understand. An executive order is not a law. It cannot repeal the National Firearms Act. It cannot eliminate the ATF. It cannot make suppressors legal without a tax stamp. What it can do is direct federal agencies to review Biden-era policies and potentially change how those policies are enforced. And that's significant. But you need to know exactly what's happening, what's changed so far, and what might change in the future. Are you subscribed yet? Because what I'm about to explain is the difference between what Trump's executive order promises and what it has actually delivered. Hit that subscribe button right now because 90% of gun owners are celebrating headlines without understanding what the executive order actually says. Don't be part of that 90%. Subscribe so you get the facts. Let me start with what the executive order actually says. The order is short. It's about 2 pages. Here's the core directive. The Attorney General is instructed to examine all orders, regulations, guidance, plans, international agreements, and other actions of executive departments and agencies to assess any ongoing infringements of the Second Amendment rights of our citizens, and to present a proposed plan of action to the President within 30 days. That 30-day deadline was March 7th, 2025. The order specifically directs the Attorney General to review several things. First, all presidential and agency actions from January 2021 through January 2025. That's the entire Biden administration. Second, any reports, documents, guidance, or plans produced by the White House Office of Gun Violence Prevention. Third, all rules promulgated by the Department of Justice or the Bureau of Alcohol, Tobacco, Firearms, and Explosives pertaining to firearms. Fourth, all agency classifications of firearms and ammunition. Fifth, the United States positions in all ongoing and potential litigation that affects the ability of Americans to exercise Second Amendment rights. And sixth, wait times and processing procedures for applications to make, manufacture, transfer, or export firearms and ammunition. The order then says the Attorney General shall present a plan of action to protect Second Amendment rights. And the plan shall be implemented in coordination with the Domestic Policy Advisor. That's the executive order. Now let me explain what this means in practice. If you're finding this helpful, imagine what you'll learn in my next video where I break down which Biden-era gun rules have actually been reversed and which are still in effect. Subscribe right now. First, the executive order does not automatically repeal any gun laws or regulations. It directs a review. A review is not a repeal. The Attorney General is supposed to look at what the Biden administration did and recommend changes, but those changes still have to go through the proper legal process. For example, if the Attorney General wants to repeal the ATF's pistol brace rule, the ATF would have to go through the Administrative Procedure Act. That means publishing a notice of proposed rulemaking, opening a public comment period, reviewing comments, and issuing a final rule. That process takes months, sometimes years. However, the executive order can have immediate effects in 2 areas: litigation positions and enforcement priorities. Let me explain both. On litigation, the executive order instructs the Attorney General to review the government's position in cases affecting the Second Amendment. This means the Department of Justice could stop defending certain gun regulations in court, or the DOJ could change its legal arguments, or the DOJ could agree to settlements or consent decrees that invalidate regulations. This has already started happening. In several ongoing cases, DOJ lawyers have filed notices saying the government is reconsidering its position. This is significant because if the government stops defending a regulation, that regulation is much more likely to be struck down. Courts rely on the government to provide historical evidence under the Bruin standard. If the government doesn't provide that evidence, challengers win. On enforcement, the executive order signals that the ATF should change its enforcement priorities. And this has already happened. In May 2025, the ATF announced it was replacing the Biden-era zero-tolerance policy with a new administrative action framework. This is huge for gun dealers. Under the zero-tolerance policy, ATF inspectors were instructed to recommend license revocations for any willful violation, even minor paperwork errors. This led to a nearly 6-fold increase in license revocations. Gun store owners were losing their licenses over things like missing serial numbers on forms or failing to record the county of residence for a buyer. The new policy restores discretion. Inspectors can issue warnings for minor violations. Revocation is reserved for serious, willful violations, and dealers who lost their licenses under the old policy can reapply. This is a real, tangible change that affects thousands of gun dealers. It's one of the clearest wins from the executive order. Hey, quick reminder, 73% of people watching aren't subscribed. That means you're going to miss updates on which regulations are actually changing. Click subscribe right now. Now, let me walk through the major Biden-era gun regulations and explain the current status of each. First, the pistol brace rule. This rule, issued in January 2023, classified pistols with stabilizing braces as short-barreled rifles under the NFA. It was challenged in multiple lawsuits. And in July 2025, the DOJ dropped its appeal in the Mock v. Bondi case. The rule is now vacated. Pistol braces are legal again at the federal level. This happened under the Trump administration, and the executive order likely influenced the decision to drop the appeal. That's a win. Second, the ghost gun rule. This rule, issued in April 2022, regulated 80% receivers and build kits as firearms. The rule was challenged and ultimately upheld by the Supreme Court in Bondi v. Vanderstock in March 2025. The vote was 7-2. The rule is still in effect. The executive order has not changed this. Ghost gun kits that can be readily converted into firearms are still regulated. That's not a win. The rule stands. Third, the engaged in business rule. This rule, issued in May 2024, expanded the definition of who is engaged in the business of dealing in firearms. It was challenged in court. In October 2024, a federal judge in Texas issued a preliminary injunction blocking enforcement against members of certain gun rights groups. The injunction is still in place. The DOJ has not moved to repeal the rule, but enforcement is limited. Status unclear. Partial win for some plaintiffs. Fourth, the NFA tax. This is huge. In July 2025, Congress passed and President Trump signed H.R. 1, which eliminated the $200 NFA tax for suppressors, short-barreled rifles, short-barreled shotguns, and any other weapons. The tax is gone effective January 1st, 2026. You still have to register NFA items, but you don't have to pay $200. This is a legislative win, not an executive order win, but it happened under Trump's administration. Fifth, the zero-tolerance enforcement policy. As I mentioned, this was replaced in May 2025. The new administrative action policy gives ATF inspectors discretion to issue warnings instead of automatic revocations. Gun dealers who lost licenses can reapply. This is a direct result of the executive order. Clear win. Sixth, NFA wait times. The executive order directed a review of processing times for NFA applications. As of now, wait times have not significantly improved. ATF is still processing Form 4 applications for suppressors in about 90 to 120 days for e-forms. That's better than it was a few years ago, but it hasn't changed since the executive order. Status, no change yet. Seventh, DOJ created a Second Amendment rights section. In June 2025, Attorney General Pam Bondi announced the creation of a new office within the Civil Rights Division, dedicated to protecting Second Amendment rights. This is historic. For the first time, the DOJ has an office treating the Second Amendment as a civil right, deserving active protection. The office is tasked with investigating state and local governments that slow-walk concealed carry permits, weaponize licensing schemes, or engage in lawfare against gun businesses. This is a structural change. It's not just symbolic. The office has resources and authority. Significant win. Quick legal note. This is educational information only. This is not legal advice. Executive orders can change. Regulations can be reinstated. Always consult a licensed attorney for specific questions. Now let me address the limitations of what an executive order can do. An executive order is a directive from the president to the executive branch. It tells federal agencies how to enforce existing laws. It cannot create new laws. It cannot repeal laws passed by Congress. And it cannot override the Constitution. Here's what that means for gun owners. The executive order cannot repeal the National Firearms Act. The NFA is a law passed by Congress in 1934. Only Congress can repeal it. The executive order can direct the ATF to streamline NFA processing, reduce wait times, and eliminate unnecessary delays. But it cannot eliminate the NFA registration requirement. The executive order cannot eliminate the ATF. The ATF is a federal agency created by statute. Only Congress can eliminate it. The executive order can direct the ATF to change enforcement priorities, but it cannot abolish the agency. The executive order cannot make machine guns legal. The Hughes Amendment, passed in 1986, banned civilian ownership of new machine guns. Only Congress can repeal that ban. The executive order cannot eliminate background checks. The Brady Act, passed in 1993, requires licensed dealers to conduct background checks. Only Congress can change that. The executive order can influence how regulations are enforced and how litigation is handled, but it cannot change the underlying laws. That's the limitation. Now let me explain why this matters. Some gun owners are celebrating the executive order as if it solved all their problems. It didn't. If you own a suppressor, you still need to register it. If you want to build a short-barreled rifle, you still need to file a Form 1. If you want to buy a gun from a dealer, you still need to pass a background check. The laws haven't changed. What has changed is the enforcement posture. The ATF is less aggressive. The DOJ is more sympathetic to Second Amendment arguments in court. And there's a new office at DOJ actively looking for state and local violations of gun rights. Those are real changes. But they're not the same as repealing the laws. Let me give you a real-world example. Let's say you're a gun dealer in California. Under the Biden administration, if you made a paperwork error, like failing to properly record a buyer's address, the ATF might have revoked your license. Under the Trump administration's new policy, the ATF inspector can issue a warning. You fix the error, you keep your license. That's a meaningful difference. But California's state gun laws haven't changed. You still can't sell standard capacity magazines. You still can't sell firearms without California's waiting period. You still have to comply with California's roster of handguns. The federal change doesn't override state law. That's the reality. The executive order helps at the federal level. It doesn't touch state laws. Another example. Let's say you're challenging a state law that bans concealed carry in certain places. Under the Biden administration, the DOJ might have filed an amicus brief supporting the state. Under the Trump administration, the DOJ might file a brief supporting your challenge, or the DOJ might stay out of it entirely. That increases your chances of winning, but it's not automatic. You still have to litigate. You still need a good lawyer. You still need historical evidence under Bruin. The DOJ's position helps, but it doesn't guarantee victory. All right, let me talk about what could still happen. The executive order directed a 30-day review. That deadline was March 7th, 2025. We're now months past that. The Attorney General has submitted her plan of action. Some of it has been implemented, like the zero tolerance policy change, but there's more that could happen. First, the DOJ could move to repeal the engaged in business rule. This would require going through the Administrative Procedure Act. Notice, comment, final rule. It would take months, but it's possible. If it happens, private sellers would have more clarity about when they need a federal firearms license. Second, the DOJ could settle ongoing litigation in ways that invalidate regulations. For example, if there's a lawsuit challenging a specific ATF classification letter, the DOJ could agree to a consent decree withdrawing that letter. This avoids the rulemaking process and achieves the same result. Third, the ATF could streamline NFA processing. The executive order specifically directed a review of wait times. The ATF could hire more examiners, improve its e-form system, and reduce the backlog. If that happens, suppressors could be approved in 30 days instead of 90. That would be huge. Fourth, the Second Amendment rights section at DOJ could start bringing enforcement actions against states. If a state is systematically denying concealed carry permits without cause, the DOJ could sue under 42 U.S.C. Section 1983. This is civil rights litigation. It could force states to comply with Bruin. Fifth, Congress could pass new laws repealing or reforming federal gun laws. The executive order doesn't do this. But a Republican Congress and a Republican president create the opportunity. H.R. 38, the Concealed Carry Reciprocity Act, could pass. The Hearing Protection Act could pass and deregulate suppressors entirely. The Hughes Amendment could be repealed. These require legislation, not executive action. But the political environment is favorable. Now, let me give you the bottom line. Trump's executive order is significant, but it's not a magic wand. It directed a review of Biden-era policies. It changed enforcement priorities. It led to the elimination of the zero tolerance policy. It created a new DOJ office for Second Amendment rights. And it signaled that the administration will not aggressively defend gun regulations in court. Those are real wins. But the order did not repeal the NFA. It did not eliminate the ATF. It did not make ghost guns unregulated. It did not overturn state gun laws. And it did not automatically make everything legal. Gun owners still need to comply with federal and state laws. What the order does is create a more favorable environment for gun rights. Litigation is more likely to succeed. Enforcement is less harsh. And there's political will to pursue further reforms. That's the realistic assessment. Your action steps. First, if you're a gun dealer who lost your license under the zero tolerance policy, you can reapply. The new administrative action framework gives you a second chance. Contact the ATF and follow the reapplication process. Second, if you own NFA items, stay compliant. The registration requirement hasn't changed. Keep your paperwork. Renew your tax stamps when necessary. The only change is that starting January to 2026, you don't have to pay the $200 tax for new applications. But you still have to register. Third, if you're fighting a state gun law in court, consider reaching out to the DOJ's Second Amendment rights section. They may be willing to support your case with an amicus brief or even join as a co-plaintiff. Fourth, support legislative efforts to repeal or reform federal gun laws. Contact your representatives. Support H.R. 38 for concealed carry reciprocity. Support efforts to repeal the Hughes Amendment. The executive order creates momentum, but legislation is what actually changes the law. And fifth, stay informed. Executive orders can be reversed by the next administration. Regulations can be reinstated. What's changed today could change back tomorrow. You need to stay on top of developments. If this video helped you understand what Trump's executive order actually does, do two things. First, subscribe. I track every major development in gun rights policy and litigation. I'll keep you updated on what's real and what's hype. Second, share this video. Every gun owner needs to understand the difference between an executive order and a law. We need to know what's changed and what hasn't. The fight for gun rights is real. The threats are real. And we need accurate information, not just headlines. Legal disclaimer. This video is for educational purposes only. It does not constitute legal advice. Laws and policies change. Always consult a licensed attorney for specific legal questions. This video reflects the status as of early 2026. Stay informed, stay legal. See you in the next one.